All right, good morning. This is a regularly scheduled meeting of Panel A. My name is Jamie Wright, and I'm the chair. Would staff please come forward and call the roll?
Dr. Bishop?
Here.
Dr. Hawkins?
Here.
Dr. Lewis?
Present.
Mr. Serrano-Sewell? Ms. Yaroslavsky?
Present.
Dr. Yip?
Here.
Ms. Wright?
Here.
We have a quorum.
Thank you. And joining me to my left is Judge Jacobs. Thank you for being here to help facilitate our oral arguments this morning.
Good morning.
Thank you. Before we do that, we're going to have the election of the panel chair and vice chair according to Business and Profession Code, Section 2008. Ms. Yaroslavsky?
May I move to maintain the hierarchy as we have in place currently?
Okay. Do we have a second?
Second.
Any discussion? No? Okay. All in favor?
Aye.
Any opposed? Thank you guys for seeing fit to elect me as chair again and Dr. Lewis as vice chair. So we're going to go on to our oral arguments. We have Dr. Atashu. All right.
Good morning, and can the folks who are here for Dr. Atashu please come forward? Good morning, we are on the record. We are here for oral argument on the non-adopted proposed decision.
Wait.
I'm sorry, Ms. Yang, do you need a few more minutes? All right, the court reporter needs a few minutes, and I've got a lot of feedback here. I don't know if it sounds like that out there. I'll move it a little further away.
Very loud up here.
Yes, it sounds, I'm going to move it a little bit away. Is that better? All right, thank you. Ms. Yang, let us know when you're ready.
Thank you.
All right. Then good morning again. We are now on the record. We are here for oral argument on a non-adopted proposed decision in the matter of the statement of issues against David A. Atashru, applicant, before the Medical Board of California. It is OAH case number 2015-010768. And does this sound as loud out there as it does to me here? It doesn't sound too loud? All right. And the medical board case number is 800-2014-006588. My name is Beth Faber-Jacobs. I'm the administrative law judge assigned to hear this matter today, assigned to sit with the board and preside over oral argument. Today is October 29th, 2015. It's about 8:20 a.m. And may I have appearances starting with counsel for complainant?
Good morning, Your Honor. Deputy Attorney General Lawrence Mercer for the Medical Board.
Good morning.
Good morning, Your Honor. Robert Willoughby here on behalf of Dr. Atashru.
Good morning.
Good morning, Your Honor. My name is David Atashru.
Good morning, Doctor. And before we proceed, there's a few things I'd like to disclose about my background and my role in this proceeding. As you know, Mr. Mercer is in the Attorney General's office. I want to let the applicant know that I used to be in the Attorney General's office for many years before I became an administrative law judge. And for the last 20 of those years, I did represent the medical board. I have not, and I also met Mr. Mercer in connection with my having been a Deputy Attorney General. I have not spoken to anyone from the board regarding this case. I have not spoken to Mr. Mercer concerning it. I have a very limited role in this proceeding. I am not the decision maker. The board will be making the decision, the final decision in this matter. But if there are legal issues that arise, I will rule on those. I believe I can be fair and impartial and provide a fair process to all parties, and I have determined that there are no grounds for disqualification. Are the parties ready to proceed?
Yes, Your Honor.
We are, Your Honor.
All right. As you've been previously advised, each party will have 15 minutes to present its oral argument, and then each will have a 5-minute rebuttal. And if the applicant wishes to address the board personally as part of his argument, he can do so, but I would swear him in first. I will give, if each party would like, I'll give you a 2-minute notice before your 15 are up unless either of you have a different request for time, and I'm happy to accommodate that. Either party have a different request?
No, Your Honor.
All right.
No, Your Honor.
All right, and then we will start with the applicant, Mr. Atashru, and his counsel. Thank you, sir. You may begin.
Thank you, Your Honor. Once again, my name is Robert Willoughby. Good morning, ladies and gentlemen. We're here today to discuss the application of Dr. Atashru following the board's non-adoption of the proposed decision. And Dr. Atashru is here to seek a probationary license. This is a young man who is at the crossroads of his professional career. And I must say, I've only been representing physicians for something like 18 years now, but I must say from my heart that I have rarely encountered a person who is of such high character as this gentleman sitting before me to my right. I can honestly say that he is an honest, caring person who has devoted a significant part of his life to community service, is someone who is very eager to learn, someone who is humble, and who someone I believe is truly capable of remediation. I've known Dr. Atashru for over a year now through this process, and obviously this has been going on for over a year. At no time has he ever complained. He's under significant financial duress. He has a wife. He is working at Stanford. His wife is a nurse practitioner at Stanford. And so, to go to the merits of this, the legal definition of incompetence, and that is the claim of which we're discussing here today, is an elusive legal definition. The board retained an expert who felt very strongly that Dr. Atashru is not competent to practice medicine and is not he is too much of a threat to public safety to be offered a probationary license. When I looked at the cases that defined the term incompetence, it doesn't seem to be anything that resembles the kind of incidents that are at issue in this case. The cases that I saw involved physicians who injected medications that were dangerous to a patient, practicing medicine while intoxicated, failure to monitor a patient during surgery resulting in death, an unnecessary surgical procedure. Dr. Atashru was a resident in a plastic surgery program at the University of Kentucky, during which there were a handful of events, which I'll discuss. But I think it should be noted that during a residency, residents do make mistakes. They are evaluated, and in this case, the overwhelming majority of evaluations of Dr. Atashru were positive. The incidents that were involved in this case were first a statement to the mother of a young patient, a burn victim, a dog bite victim during Dr. Atashru's intern year. Dr. Atashru admits that he made a mistake by making a statement regarding papoosing the child to the mother. There was no patient harm as a result of this. Dr. Atashru did not make any kind of treatment plan outside the scope of his residency purview, but he did make an improper statement. He apologized, and he admits that that was improper. Later in his career, there is an email in his file relating to the evaluation of a breast abscess. Dr. Atashru expressed the concern that this might require surgery, requiring a senior physician to be called into the hospital on the night before Christmas, which caused the supervising attending physician to be upset. However, Dr. Atashru's concern was validated by the fact that that patient needed to go to surgery. There was another incident in which there was only a short handwritten note in one of Dr. Atashru's evaluations that refers to a handoff of a consult for a patient with free air. Dr. Atashru has explained that that handoff was not to a resident, as was indicated in the handwritten note, but was to a pulmonary fellow. Dr. Atashru was appropriately going up the chain of command. He had another surgery that he needed to attend to, and so he appropriately asked for the specialist, the pulmonary fellow, to be involved. There was a fourth incident in which a patient's hand was burned by unexpectedly hot water in an automatic sink in the emergency department. Dr. Atashru fully admits that he should not have left this patient attended. Of course, Dr. Atashru had no reason to believe that this water would become scalding hot. It was an automatic sink, and in fact, the University of Kentucky took responsibility for the temperature of the water. I want to really spend as little time as I can here today because I want to leave as much time as possible for you to meet Dr. Atashru and talk with Dr. Atashru. I think you'll find, as I have, that he is someone of exceptional character and honesty. At the hearing, Dr. Atashru had one expert, a non-paid expert, Dr. Andrew Polito, who is the former chairman of pediatric plastic surgery at the University of Kentucky. Dr. Polito now has cut back some of his hours, but he is still in active practice. And I must say that he is one of the most experienced and respected pediatric surgeons in the United States. Dr. Polito has personal experience evaluating Dr. Atashru. He stated that without a doubt in his mind, Dr. Atashru is competent to practice medicine. Dr. Atashru obviously had what can be conservatively termed as a personality conflict with an attending physician in the plastic surgery department at the University of Kentucky. That physician physically assaulted Dr. Atashru. He insulted him in front of others. He refused to work with him. This is obviously a very difficult situation for Dr. Atashru, and the board's expert took the position that Dr. Atashru should have grieved this situation. Unfortunately, Dr. Atashru, it's not in his personality to cause trouble. He always wants to work out situations. He did not grieve. He did not complain. He put his nose down and tried to work harder. I want to draw the board's attention to a few of the letters that stand out in Dr. Atashru's file. Exhibit E is a May 2014 letter from Dr. Rinker, who's one of the attending surgeons in the plastic surgery program at the University of Kentucky. Dr. Rinker gave his strongest recommendation for Dr. Atashru when Dr. Atashru was trying to reapply to the plastic surgery residency program at UC Davis. When I say reapply, He wanted to re-enter another plastic surgery program. Of course, Dr. Atashru could not re-enter that program without a medical license in the state of California. Exhibit 8 in the board's exhibits, pages AG 13 to 14, Dr. Iacono in the plastic surgery program called Dr. Atashru one of the most improved residents in that program's history. Dr. Atashru will freely admit that the second year of his plastic surgery program was a problem, a year in which he made mistakes, a year that he needed to improve. But I would submit that if you look at the evaluations closely and the letters that we have submitted, Dr. Atashru made great strides in his third year, and that he showed a readily available or a ready ability to improve his deficiencies. Exhibit V is a letter from Professor Carney, another very respected plastic surgeon at the University of Kentucky. Dr. Carney states that Dr. Atashru will be an excellent physician. Exhibit W is also a letter of recommendation to the UC Davis Plastic Surgery Residency Program by the chair of the UK Plastic Surgery Program, Dr. Vasquez. Dr. Vasquez also recommends Dr. Atashru to the program. I submit that these attendings would not recommend Dr. Atashru to these residency programs if they found Dr. Atashru to be incompetent to practice medicine. Finally, Exhibit A is a letter from Dr. Stewart, another attending at the University of Kentucky Plastic Surgery Program. This letter states quite clearly that Dr. Atashru is not incompetent and that none of the evaluations or the summative letter that was written upon Dr. Atashru's departure from the University of Kentucky should be interpreted as saying that Dr. Atashru is incompetent. I really want to let Dr. Atashru talk to you and address your questions. I just wanted to mention that in terms of remediation, Dr. Atashru, after leaving the University of Kentucky, has continued to work in medicine. He has been a researcher at Stanford. He has also volunteered in a program called Co-Pilots in Care, in which he volunteers his time to assist older adults at the end of life. He's been invited as a guest lecturer at UCSF as a result of his work in this project. While working as a researcher at Stanford, he is continually evaluated by plastic surgeons in that department who have also written positive reviews that are part of this file. Finally, he has also continued to take CME courses through MD Anderson, including courses on practice and communication and professionalism. In summary, we would like to request that Dr. Atashru be considered for a probationary license. We thank you for your time. We realize this was a great expense and amount of time that the board has spent on this, and again, we thank you.
It's my understanding that Dr. Atashru, you'd like to speak at this time? Then let me swear you in. If you please rise, raise your right hand. Do you solemnly swear under penalty of perjury that the testimony you'll give today, the statements you'll make today, will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Please have a seat. And you have 2 minutes and 50 seconds left.
Sure. I know we only have a few minutes left, so I'll try and be brief. I'd like to again start off by just saying thank you. I know this is unusual, and I appreciate the board taking the time and the expense to come and give me the opportunity to speak. So my thanks. I'm grateful. And I do want to again acknowledge that my intention is to seek a probationary license so that I can re-enter residency training or at least supervised medical training. I'm not intending to practice independently. I want to go back into a supervised position to finish training, to improve and continue to improve my ability to practice. I will say that residency was at Kentucky. I encountered difficulties that I hadn't encountered before, but I believe even since then and since leaving, I've truly committed myself to rehabilitating and remediating and improving areas that I found I might be deficient in I think this experience has been certainly one that sponsored reflection and self-reflection and was an exercise in humility. I believe I'm in a position now where, and especially in the time since I left Kentucky, I've spent time learning to improve my communication, improve my work with patients, and also dedicated myself to mindfulness and understanding boundaries and making sure that I know where the limits are and when to ask for help. So I respectfully submit that that's my intention, to go back to be able to be in a supervised position for training, and I think that I could rehabilitate, and I have remediated, and I'd be ready for that. If you look at my record, I have spent my whole life dedicated to helping people, from undergrad to medical school, and even into residency. I've dedicated myself to helping the underserved. That still remains true. My intention of getting a license is to one day be able to do the same for the people of California. Thank you.
Thank you. All right, if you'll give me 1 second, we'll reset the clock. Mr. Mercer.
Good morning, members of the board. I'm here to address what we agree is the single issue, that is whether the applicant should be granted the probationary license that he's requesting. I think that I'd like to take a moment and just clarify the role of the AG in these cases. There may be some misunderstanding that we're just hired guns, that when we get a statement of issues sent to us by the board, that our only goal is to get a license denial, and that's not the case. Our role, if we have one important function, is to bring forth the evidence and put together a full record for the administrative law judge and for yourselves. And we believe that this administrative record contains more than ample evidence to support the decision, and for that reason we ask that the decision be adopted by you. I would like to clarify a couple of legal points at the outset, which were raised by Dr. Adeshru in his argument. And first off, we need to start with the decision. The decision did not find Dr. Adeshru to be guilty of incompetence. The decision found him to be guilty of unprofessional conduct. And as the board members are aware, we can and do place physicians on probation. We even revoke physicians for unprofessional conduct. That being said, I would suggest that we did, in fact, prove incompetence. What the incompetence was is not, as counsel stated, clearly set forth in any of the reported decisions, because we don't have any reported decisions on statements of issues involving competency. There just are none. And every case is based on its own facts. In this case, I would submit to you that incompetence was shown by the repeated failure to translate what was admittedly sound medical knowledge into practical experience in a clinical setting. To put it bluntly, Dr. Adeshru hit the wall in his residency. He was a great medical student. He did well on tests, but when it came to his residency program, he hit the wall. And if we look at the evidence, which is recited in the decision and which we have set forth in our own argument, it started in his first year with a letter of concern. It moved into his second year with a probation. He was given the extraordinary opportunity to repeat his second year, which is an expense and a time drain for a program director, but nevertheless, they hoped that he would be able to remediate, but he was not able to do so. In the end, they were compelled, despite the amount of time, energy, and money that they had spent on this resident to terminate him from the program and to issue the letter referred to by my colleague indicating that he was deficient in 4 of the 6 core competencies. And those competencies, as stated by the board's expert, involved all kinds of care that apply generally to every specialty, not just to plastic surgery. And that's important because, of course, what we're talking about here is he competent to practice as a physician having failed his plastic surgery program? And if we look at the cases, beginning with the Papoosing incident, we see a failure to do a complete evaluation. We see discussion of a treatment plan without consulting with the other members of the care team, and ultimately a lot of confusion and upset on the part of the parents because they're being given conflicting reports. Even if you look at the most recent case, the last case, the straw that broke the camel's back for UK, you have a patient who presents with a wounded thumb, and Dr. Adeshu properly numbs the thumb, but then inexplicably leaves the patient in the room alone to wash out his own wound. Clearly, with a numb thumb, there is an opportunity for patient harm here, and patient harm did occur, and Dr. Pulido said, yes, there was patient harm as a result of this problem. Dr. Pulido said, yes, Dr. Adeshu made mistakes, and Dr. Adeshu here this morning says, I made mistakes. Our concern is that, yes, residents make mistakes, but they don't make the same ones over and over again. And we see the Papoosing incident followed by Dr. Wong's report that he was so busy debriding a wound that he was unaware that the mother was extremely upset with what was going on in that examining room. We spent a good deal of time setting forth all the facts of this case. I'm not going to dwell on them. I would like to turn my attention to what I think is the concern of the board here this morning, and that is the penalty. Is the penalty too harsh? We submit that the penalty is supported by the evidence. We submit that the penalty is in the public interest, but we also understand that we are here on a non-adopt. That means that at least some of the panel members are concerned that this is too harsh. And our response is that the board's concern has to be for the public in these cases. If the board, however, disagrees that Dr. Adeshu's continued practice would be a threat to the public safety, the board does have the option to grant him a probationary license. We pointed that out in our brief. We also pointed out that key to that probation would have to be a practice monitor who would be responsible for reporting to the board. We have probation inspectors who monitor probations. They are untrained. They are unable to follow closely every one of our licensees. It is necessary that a medical professional be involved in this and responsible for reporting to the board if that's the direction that the board chooses to go. And I think I'll leave it there. Thank you.
Thank you. If you'll just give me 1 minute, sir, I'll reset the timer. All right, Mr. Willoughby, you have 5 minutes.
Okay, thank you, Your Honor. Page 19 of the Administrative Law Judge's decision discusses the legal conclusions, and I do believe within the category of unprofessional conduct, it is incompetence that was the basis of the decision. I really have nothing further to submit and would like to table any additional time so that Dr. Tasheru can either speak or respond to any questions that you all might have.
All right. Is there anything further, Dr. Attashru, you wish to say at this time?
At this time, I think I'd love to be able to answer any questions that the board may have regarding my case or my application. I think that's one of the things that, even from the get-go of my application, I submitted to the board when I applied. I would really love for you just to get a chance to meet me and talk to me and get a chance to hear my side of the story, or how I think I should be able to practice medicine safely and in the best interest of the public. And so if I can use that time to do that now, I would appreciate that.
Are there any questions from the board? Then, Dr. Lewis?
Good morning. I have quite a number of questions, so my panel members will have to bear with me. First question is for Dr. Attashru. Why did you not file a grievance to your superiors with your statements of this kind of conduct?
Dr. Lewis, it's a really good question, and I think about that quite a bit. I'll tell you, in the situation in the moment, what I did was I reached out to my upper-level residents and asked them for advice. And the unanimous response from my upper-level residents was, don't do that. Keep your head down, just push through, don't do that. You're going to rock the boat. Whenever you have an evaluation like that or have a meeting that's like that, just say, yes, sir, accept whatever they say, and don't do anything. The second thing is, at the end, when it got to a point where it was becoming untenable, I did go to my ACGME representative at Kentucky, the one that was in charge of the GME and the representative to the ACGME residency, and I told her what was going on. She then investigated it. I came back a week later, and she said she confirmed the allegations. And then I asked her, well, what should I do? Should I grieve? And she said, you can grieve, but it's not going to make a difference. And I think at that point, this is that person telling me it's not going to make a difference, and me realizing that if you've got a situation where you've got 5 faculty members and you're requiring all of them to be involved in training you, I knew I wasn't going to be able to get the training I needed.
Do we have that as submitted in the record? I don't remember that. Is there a document that says you did that?
Dr. Lewis, there's no document of that. I mean, I think it probably stands to bear that if I asked that ACGME rep, would she go on record of saying that? I don't think she would.
I do want to note that we have to stay within the confines
Yeah.
of the current record. We can't
So
look
it's not
for
in there,
additional
okay,
evidence.
sorry. I have a question for, let's see, who's my next question? For Mr. Mercer.
Good morning.
Good morning. There were conflicting statements you made, and I need clarification. I have written down here, you made a statement that we're looking at the guilt of unprofessional conduct, and then you segued into incompetence, and I'm a little troubled by those two statements. They're
apologize.
confusing to me.
I may not have been clear. Let me
No.
be clear. At the administrative hearing, we put on a case, and we asked the administrative law judge to find incompetence. He did not do so. My statement to find incompetence. My statement with regard to unprofessional conduct was to point out that the administrative law judge did find the applicant to be guilty of unprofessional conduct. My second statement with regard to unprofessional conduct is that it is our position that the administrative law judge should have found incompetence. The reason he should have found incompetence is because we have a resident who, despite multiple opportunities to remediate, was unable to do so, meaning that he was unable to translate book knowledge into sound clinical practice. If you look at the pediatric surgery letter that was issued in the middle of his PGY2, that letter states that despite apparently adequate medical knowledge, he was unable to identify appropriate facts and come up with a good differential diagnosis and a sound treatment plan. So yes, we believe that the ALJ should have found incompetence and that should have been grounds for discipline, and we believe that should be considered in your consideration of the penalty. We have serious concerns here, and I don't think that Dr. Adeshru is denying that.
I have one last question also of you. I think this was within the purview of the board. You said the board's expert, Dr. Nuovo, was involved in reviewing this case or opining on the case, but I'm not clear on what Dr. Nuovo actually reviewed, because I don't know if he reviewed just, statements from the professors, or did he review the cases in question? So can you clarify that for me, please?
I can clarify it. I would start off with pointing out that Dr. James Nuovo is the Associate Dean of the University of California, Davis Medical School. He has been involved in residency training and education for 30 years. He currently oversees 60 programs, 700 residents, of whom he stated he's remediating 5 to 10% at any given time. With that said, I'm sorry, could you repeat?
Yes, we know Dr. Nuovo very well
Okay.
and his expertise. My question is, what did he review? Because I don't see it in here, what
Thank
he
you.
reviewed.
He reviewed everything he was
Record.
given, which is everything that you have. He reviewed the entire application, which is everything that Dr. Adeshru felt was important for the board to know. He reviewed all of the documents from the University of Kentucky, which included all of the faculty evaluations. Now, those are important because who are the faculty? They are the designated ACGME reporters who are responsible for periodically evaluating Dr. Adeshru's progress. And that was what was the basis for his opinion that despite repeated opportunities to do so, he was unable to remediate.
But Mr. Mercer, did he review the cases that were in question that led to the charge of incompetence? Do you know if he did?
I believe what you're asking me is, did he review medical records?
Medical records of those patients that were involved in the alleged incidents that led to the incompetence charge?
And that brings us to the unique aspect of this case, as in all other applications where the applicant comes to us from another state, and that is that the board's subpoena power only applies to the state of California.
1 minute.
We will never have those records.
Thank you.
If there are any other questions there, yes, because the applicant still has another minute left. Yes, doctor.
Dr. Hawkins. Thank you. Dr. Tasher, in the record, there's an indication that perhaps a medical diagnosis may have been a factor in some of the interactions. I don't know if you still believe that. I do have a question whether that condition, if it does exist, is being treated, and whether that was a factor, is a factor going forward.
Yes, Dr. Hawkins. I think with the rigor of residency training, I think all of us would know you have to be spot on. There's just no room for margin there. You have to be at your best. And so during residency, found that I guess I should have known from being young, but I was able to compensate until residency, ADHD and meibomianitis, 2 conditions that were treated in my second year of residency and made a drastic improvement in my third year. So those are currently being treated, and they help tremendously. The one, ADHD, and then the second, meibomianitis, being my eyes would dry out during residency. It makes it difficult to operate through your loops, so I switched that out with, now I operate only in my glasses. I got my prescription into my loops, and I use it's a warm compress, opens up the tear ducts. It makes it easier for me, for my eyes not to dry out. And that addressed all those issues.
Any further questions? There's another minute left, if anyone. All right. Then with that, thank everyone. This matter is now under submission. The board will be meeting in executive session.
So we're going to go into closed session, so if everyone could leave the room, and we'll call you back in once we've completed our...
Is that it?
right, are we ready to go on the record? Everyone ready? Then good morning. We are on the record. We are here for oral argument following a grant of reconsideration in the matter of the petition for reinstatement of a revoked certificate of Samantha Landy Liu before the Medical Board of California. It is OAH case number 2014-120985 and Medical Board file number 800, 2014, 003701. My name is Beth Faber-Jacobs. I'm an administrative law judge. I've been assigned to sit with the board today and preside over this matter during oral argument. Today is October 29th, 2015. It's about 9:25 a.m. Counsel, may I have appearances for the record, starting with the counsel for petitioner in this matter?
My name is Marvin Firestone, and I'm representing Samantha Liu, who's sitting next to me.
Good morning, sir, and good morning, Ms. Liu. And for the Attorney General's office?
Deputy Attorney General Lawrence Mercer for the Medical Board.
Good morning, Mr. Mercer. Before we proceed, there's some information I'd like to disclose about my background and my role in these proceedings. As you know, Mr. Mercer is in the Attorney General's office. I used to work in the Attorney General's office for many years before I became an administrative law judge. And during the last 20 of those years, I did represent the Medical Board. I was in the same section as Mr. Mercer, although we worked in different cities. I wanted petitioner to know that I've not spoken with anyone from the Attorney General's office or the Medical Board in this matter. And I have a limited role in this proceeding today. I am not here as the decision maker. I will be assisting the board, but the board will be making the decision in this matter. If legal issues arise, I will rule on those. I've determined that my familiarity with the Medical Board and the Attorney General's office is not grounds for disqualification, and I believe I can be fair and impartial, provide a fair and impartial proceeding today to all parties. But if there are any questions, I'm happy to answer that. Are the parties ready to proceed?
We are, Your Honor.
Yes, Your Honor.
All right. As you've all been previously advised, each party will have 15 minutes to present that party's oral argument and then 5 minutes for rebuttal. And if petitioner wishes to address the board personally as part of her argument, she can do that, but I will swear her in first, and her time will come from her oral argument side. And if the parties would like, I can give you a 2-minute notice or whatever amount of time you would like. Mr. Firestone, is 2 minutes fine, or would you like a little bit more?
2 minutes are fine.
All right, Mr. Mercer?
Also fine, Your Honor.
All right. Then starting with the petitioner, Mr. Firestone, you have 15 minutes. You may proceed.
Thank you, Your Honor. Good morning, Medical Board panel members. As I introduce myself, my name is Marvin Firestone, and I have the distinct honor and privilege of representing Samantha Liu with regards to this proceedings and before the Honorable Medical Board panel. I'd like to tell you a little bit about Samantha. Samantha was graduated from the UCSF residency in general psychiatry, and then was graduated from the fellowship program in child psychiatry. Soon after she completed this training program, she had a patient, a psychiatrist who was on probation with this Medical Board. He was diagnosed as having bipolar disorder. It so happens that Samantha also has a diagnosis of bipolar disorder. In 2004, soon after termination of treatment of this patient by Samantha, he came back to see her and was perceived by Samantha to be seductive and intimidating. Due to her inexperience, her poorly managed bipolar disorder at that time, and her problematic childhood upbringing, Samantha was unable to manage this patient's transference behavior towards her. It led to an affair for a 2-month period. She then behaved in a dishonest manner to cover up the egregious behavior on her part. Due to these unprofessional acts, Samantha's license was revoked by this board in 2007. The reconsideration case before the medical board right now involves denial of Samantha's petition for reinstatement of her medical license a couple months ago. Reinstatement is warranted because Samantha is honest and she's now rehabilitated and safe to practice medicine. Here are the reasons for reconsideration of the denial and why it's warranted. Number one, the decision unfairly punishes Samantha for the prior underlying offense, rather than giving a fair evaluation of the evidence presented of her present state and her rehabilitation. Number two, Samantha has met her burden to reinstate her medical license and has provided reliable evidence that she accomplished rehabilitation, she received the remedial learning that the board and society would expect in order to rehabilitate from the mistakes she made over 11 years ago. After all, it is unfair for this physician to continue to have a scarlet letter on her forehead. Number three, the legal reasoning and conclusion by the ALJ, the administrative law judge, that Samantha is dishonest are not supported by the evidence, are erroneous, and are inconsistent with society's goal of remediation. And number four, the findings and conclusions of the ALJ are based on a lack of consideration of all the relevant evidence, even substantial evidence of rehabilitation, and therefore the decision must be modified. Thomas J. Brady, MD, a board-certified child and adult psychiatrist and an addictionologist, served as an expert witness at the administrative hearing. He had no prior relationship with Samantha, did not know her prior to my retention of him to do a thorough independent evaluation of her. He did not receive the 2007 decision, but relied on his learning of the facts in the decision from interviews he had with Samantha, her consultants, and her care providers, as well as the summary of the decision which I provided Dr. Brady when he was retained by me. Douglas Anderson, MD, Samantha's treating psychiatrist, and Adam Travis, MD, who's Samantha's husband and sitting behind me, is a psychiatrist, chief of psychiatry at the Northern Region of Kaiser. Both these psychiatrists provided supportive statements for the ALJ's and the board's review. Despite evidence to the contrary, the ALJ opined incorrectly that, quote, the evidence showed the petitioner still is either confused or does not truly accept responsibility for what occurred, and the underlying dishonest conduct is not sufficiently acknowledged or addressed, end of quote. That's in the decision that you have received, paragraph 3, page 12. In seeking reinstatement of her medical license, Samantha was required to satisfy a demanding burden. And I submit to you that she has done so by clear and convincing evidence that she is rehabilitated. The board has received convincing evidence that establishes that Samantha is rehabilitated and is safe to practice. She has done what the board and the members of the public would demand of any licentiate who has lost his or her license and the trust of the public. She has taken steps to remediate the situation that led to her license revocation, including intensive psychotherapeutic treatment, board-approved medical record-keeping, professional boundary and ethics courses, and providing many hours of community service. She's made amends with her family and has kept current in her medical and psychiatric knowledge by attending many more hours of continuing medical education programs than are required of a licensed physician. Dr. Anderson, her treating psychiatrist, opined, and I quote, "Of particular note is her increasing maturity and sense of responsibility. She has more clearly seen her role in her difficulties that existed prior to the license removal. She has become increasingly humble, accepting of responsibility, and has learned a great deal about herself. Thus, today I see a much healthier and well-balanced Samantha Liu than ever before. I am confident that if allowed to regain her medical license, she will comport herself in a very professional and ethical manner. I ask the board to strongly consider allowing Samantha Liu to regain her license with whatever safeguards you deem necessary." End of quote. Professor Patricia Spire, MD, testified at the administrative hearing. She has been Samantha's ongoing mentor and consultant. Dr. Spire has known Samantha since she was a psychiatric resident and trained her as part of the fellowship in child and adolescent psychiatry. Dr. Spire also wrote about Samantha Liu, as I will quote, "Someone who was very bright and eager to learn, someone who was very naive, but someone who has and had a good heart." End of quote. Dr. Spire opined in her testimony at the administrative hearing that Samantha has made significant progress over the last several years. She stated, quote, "She came back with a renewed conviction that she could again become a psychiatrist, that she was fully rehabilitated. And after discussing with her at some length and reviewing things again, I felt that she was rehabilitated. In my professional opinion, Dr. Liu is fully rehabilitated, and she is able to practice medicine with a full understanding of her professional role and responsibilities. She has a deep intention to be a good physician, and she now really understands the boundaries that are required in practicing as a professional psychiatrist and responsible physician. And I have no hesitation that she will safely practice psychiatry in the future if her license is returned. She takes responsibility for her losing her professional boundaries, for her allowing herself to be intimidated, for her seeing herself as being coerced where it was not clear whether she was being coerced or not. She takes responsibility for the egregious breaches that she committed. She shows clear remorse for all of this." End of quote. I'd like to address Samantha's honesty. In light of Samantha's past dishonesty, the board is entitled to be exacting in its requirements as a proof of her rehabilitation with respect to honesty. I submit that Samantha has met this burden and testified honestly and consistently, as well as being honest with her treating and supervising psychiatrists, and with Dr. Brady, the expert who did the independent assessment of her. The ALJ made a critical error by ignoring Dr. Brady's opinions in his report and testimony. The totality of the evidence supports the fact that Samantha has demonstrated that she is no longer deserving of the adverse character judgment associated with the 2007 license revocation decision. It was assumed that Samantha was being dishonest because she described her relationship with her former patient differently at different times. The ALJ stated that the heart of this case is Samantha's honesty. Samantha has explained what was going on inside her head at the time that she initially felt that she was a victim and was trying to better understand how and why she misperceived the complicated relationship she had with the patient in 2004. The ALJ made an unfair assumption that Samantha was dishonest when she reported her past frame of mind, conflating it as a report of the findings of fact in the 2007 decision or as her current thinking. Samantha's description of her perception was taken out of context by the ALJ. Dr. Brady performed his initial examination of Samantha in November 2013, and again a week before the administrative hearing. Samantha sent an email to Dr. Brady shortly following her evaluation in November of 2013. Contrary to the finding in paragraph 23 of the ALJ's proposed decision, she was not taking a victim stance. She wrote to Dr. Brady in November 2013 as follows, quote, "Despite all said, I should not have let any of those incidents happen. Instead of seeing myself as a victim, I should have taken charge of the situation and handled the issues that were handed to me. Being the psychiatrist dealing with a mentally ill patient in this particular circumstance, I had the responsibility of keeping both my patient and myself safe first, and then getting the police to take the patient to a psychiatric emergency facility for evaluation in this case. I feel remorseful about my lack of responsibility and competency at that time due to my own psychiatric and psychological problems. After many years of therapy and rehabilitation, the mistake will never happen again." End of quote. Dr. Brady opined at the hearing before the ALJ, quote, "I have determined that she has done extensive rehabilitation work with a therapist, as well as an extensive amount of continuing education, consultation around issues of boundaries and ethics that she continues with at this time. Her mental status examination at the time of the interview in November 2013, and also my reevaluation last week, showed her to have a normal mental status examination, normal thinking, no abnormalities found, a quite intelligent, articulate individual who has significant remorse over her ethical violation, and I concluded that she could operate as a psychiatrist safely with the public."
2 minutes, sir.
Thank you. Dr. Liu has gone through a transformation over the past 7-8 years, whereas before she saw herself victimized by her previous patient. And to me, that speaks to lack of responsibility for her actions. I see that that has reversed, and she has expressed a strong awareness of her violation. She's remorseful about it, that she has transgressed and gave up her power, so to speak, in this relationship with this mentally ill patient." End of quote. Dr. Brady opined that Samantha does see herself as responsible for what occurred. Dr. Brady opined in his written report, quote, "Dr. Liu recognizes the gravity of her ethical breach, is remorseful, and has worked diligently in a number of ways during the past several years to rehabilitate herself. I judge Dr. Liu safe to return to practice her specialty of adult and child psychiatry. There is a great need for Samantha's psychiatric services in an underserved patient population." End of quote. Samantha Liu speaks excellent English as well as Chinese. She is the one and only Chinese-speaking psychiatrist in the San Francisco Bay Area who is trained to treat children. She is active in the Chinese-American community and would like to continue her career treating this underserved Chinese patient population. In conclusion, the mistakes Samantha Liu made nearly 11 years ago should not in and of themselves bar her from securing reinstatement of her license. She has met her burden of showing that she is rehabilitated. Disciplinary action is not intended to punish, but rather should be meted out with the goal of rehabilitation. Here, Samantha has spent the last 8 years accomplishing an excellent rehabilitation. Therefore, Samantha Liu, MD, respectfully requests the Honorable Medical Board to reconsider its decision and grant her reinstatement of her medical license so that she can resume her life's work as a child psychiatrist serving a much underserved patient population in California. Thank you for your attention.
Thank you, sir. All right, Mr. Mercer.
Thank you, Your Honor. I'd like to clarify the standard of review on this case. We've heard a lot about meting out discipline with an eye towards rehabilitation. That is simply not applicable to this case. Samantha Liu is not a licensed physician. She is a revoked physician. She is not a licensee, and the board does not have a duty to rehabilitate her. It is her obligation to come to this board fully rehabilitated. And I was just looking at a state bar decision. Unlike physicians whose cases go to the Superior Court, attorney discipline goes directly to our highest court, the Supreme Court. And the Supreme Court stated in Wetland versus State Bar, one who has been disbarred for acts involving a high degree of moral turpitude, which we certainly have here, and those committed by petitioner were of that character, should not be reinstated in the ranks of the legal profession except upon the most clear and convincing, nay, we will say upon the most overwhelming proof of reform, proof which we could with confidence lay before the world in justification of a judgment again installing him in the profession. I would submit that we simply don't have that here. This case is one of the most egregious cases I've ever seen, and both of the experts called by Samantha Liu called it egregious and horrifying. She embarked on a 2.5-month sexual relationship with a severely disturbed psychiatric patient, gratifying her own personal needs, and then when she became aware that her own license was at stake, she claimed that she had been repeatedly kidnapped and raped. Now, psychiatrists do occasionally commit that supreme sin of having sexual relations with a patient. And in most of those cases, the psychiatrist said, you know what, here's my license. I did it, there's nothing I can say about it. In this case, Samantha Liu forced the board through a full hearing, at which time she presented a defense that she suffered from Stockholm Syndrome and was a hostage much like Patty Hearst. After the hearing, she continued to see herself as being the victim. She filed a petition for reinstatement in 2012, and that was denied. That decision said, we don't have an objective evaluation here. So Samantha Liu went out to get an evaluation. However, it was not an objective evaluation. As the record makes abundantly clear, the critical document, the 2007 decision, which outlines all of her unethical and dishonest acts, was never given to the evaluator. At the hearing, he said, you're right, I've never seen this before. In his testimony, it became apparent that he was unaware of absolutely critical facts to finding out what exactly happened here, because you can't see how far someone has come until you find out where they came from. Past behavior is the best predictor of future conduct. And in this case, he was unaware that following the initial sexual encounter, which was not after termination, but was in fact the termination meeting with her patient, as stated in the decision, which is now the law in this case, she arranged to meet with the patient again the following day. And the day after, and the week after, and the weeks after that, she engaged in a voluntary sexual relationship with the patient, where she talked about their running away to Florida. She actually obtained a Florida medical license during the course of the affair with that intent. This is all set forth in the decision, and the evaluator had no idea. Instead, what did he get? He got an email, Exhibit 3, from Samantha Liu, which states, the patient suddenly showed up after termination to demand sex. Well, it wasn't after termination, and when the officers who were called by her husband came to the office, she said, no, this is a consensual sexual relationship. He also was not aware that when the officers showed up, there were empty ampules of nitrous oxide and marijuana cigarettes that had been imbibed during the office preparatory to the sexual encounter. She told Dr. Brady that she did what he wanted out of fear of retaliation. Again, no mention of the fact that they went to hotels, restaurants, they were in public places together on a consensual relationship. She did not tell Dr. Brady that when it became apparent that her own license was in jeopardy, she decided to accuse the patient of sexual abuse, kidnap, and rape. As a result, her own patient, her own former patient at that point, was charged with a crime. But her testimony was so inconsistent that the charges were dismissed. Now, in her statement to Dr. Brady, she said, "I was crying a lot and my testimony was inconsistent." This is hardly an admission that she perjured herself in a criminal trial. And finally, she stated, in order to sue me for money, he made up some stories and testified against me for the board. The board believed that patients are always right. You know, quite frankly, there's not even a veneer of rehabilitation here. There has been some rehearsed statements. She also called Dr. Spire, Patricia Spire, who is a reputable practitioner, but Dr. Spire was working from a different angle. She was not objective. She was working from a kind of therapeutic alliance, although she was a consultant. She did say that she assured Samantha Liu that she would be supportive. In fact, she was so supportive of Samantha Liu that when Samantha Liu went and got the transcripts of prior hearings to prepare her answers to questions at the hearing on her petition for reinstatement, they rehearsed her possible answers. There just wasn't a genuine showing of rehabilitation here, and certainly not the kind of rehabilitation that this board could place before the world in justification of reinstalling her in the profession. She violated her most sacred obligation to her patient by exploiting him for her personal interests, and contrary to her position that the board should not consider the underlying incident. In fact, the board is required to consider the underlying incident. Two factors that are set forth in 2307 are what are the underlying facts and what is her reputation for dishonesty. And both of them in this case are shocking and abysmal. Samantha Liu comes forward today and tells you that she has done extensive counseling. She's taken courses in boundaries and ethics. Our position is that ethics is not something that you can get from a course. You have it or you don't. You have a moral compass or you don't. As demonstrated by her November 2013 email, she continues to blame the patient. She continues to believe that the patient lied about her for money and to assist the board. This is not the kind of showing, not even close to the kind of showing that the board should be requiring. And I have not even touched upon the fact that she falsified her patient's chart to protect herself. I mean, this is mind-boggling. It really is. She had produced the chart in 2004 when she thought that the patient was under investigation. And then in 2005, when she realized she was under investigation, she came forward without any request and said, "Oh, here's his chart." And it contained 3 chart notes that she had simply written for the purposes of covering for herself. She didn't do a very good job because she accidentally dated them 2005 instead of 2004, which of course rang some alarms, and when the 2 charts were compared, it was clear that there had been some fabrication. But even today, in her statement in Exhibit 5, this is her email to Dr. Spire, she states that in the frantic rush to comply with the medical board, she negligently wrote up some notes. Well, that's not at all what happened. That's not even close to what happened. What happened was that she fabricated 3 chart notes relating to 3 meetings right before they began their sexual relationship to cover for herself. Again, I know I'm probably just repeating myself at this point, and I probably should just say there is no rehabilitation here. You really need to, after reconsideration, agree that the board the first time did the right thing and adopted the proposed decision. Thank you.
Thank you, sir. Give me one moment, and I will change the time here. All right, sir, you have 5 minutes.
Thank you, Your Honor. This board is not asked to rehabilitate Samantha. She has made tremendous efforts to accomplish rehabilitation, and I think she's done a good job in accomplishing that, according to those who know her best. Dr. Brady, actually, Mr. Mercer is criticizing all the experts that testified, Dr. Brady, Dr. Spire. Dr. Brady was fully aware of the facts of the 2007 decision. He interviewed Dr. Anderson, Samantha's psychotherapist and psychiatrist, who has known her from 2003 until the present. And Dr. Anderson shared all his understanding of what's transpired. Dr. Brady interviewed Professor Spire, who has known Samantha since her residency and fellowship all the way through to the present, and served as a consultant as well as a mentor to Samantha. Dr. Spire reviewed all the transcripts of all the testimony and the decisions with a fine-tooth comb so that she acquired a complete appreciation of the facts related to Samantha's situation so that she could better mentor her and be a consultant to her. Mr. Mercer is still arguing the facts of what occurred 11 years ago. She's been punished by losing her license. She is not the same person she was in 2004. Keep in mind she has taken extensive courses in ethics and professionalism and boundary issues. She has seen a psychiatrist in therapy sometimes 2 or 3 times a week, and she has continued counseling with Dr. Spire a couple times a week for many years. She is a changed person, and it's not right to continue to see her with a scarlet letter on her forehead based on her egregious behavior 11 years ago. Thank you.
Thank you, sir. All right, Mr. Mercer, you have 5 minutes.
Thank you, Your Honor. I'll be brief. I'll just point out a couple of things that I think are important to your reconsideration, and that is that Samantha Liu, when she was practicing, was a psychiatrist. Psychiatrists, I think it's generally known, have access to the most vulnerable patients of our patient population. The protection of the public requires that you err on the side of the public and not on the side of the revoked physician. And certainly, and I think we tried to say this, and I'd like to say it again, the protection of the public is as much about the public's perception that it is being protected as it is about stopping wrongdoers. And quite frankly, it is our position that to reinstate Samantha Liu on this showing, on this inadequate showing, would undermine that confidence. The public would perceive that a physician could violate her most basic obligation to the patient, not to exploit that patient for her personal gratification, and yet come back and simply recite some routine words of contrition and be reinstated to the profession. I don't believe, and I don't believe this board believes, that that's the kind of message that we want to send to the public. Thank you.
Thank you. Do any of the board members have any questions? Yes, Dr. Lewis.
Yes, hi, good morning. I have a question for Mr. Firestone. I'm looking at the ALJ's comments. It'll be paragraph 21, 22, 23, and 24 regarding the opinion of Dr. Brady. And you made a statement that Dr. Brady, and we can also say Dr. Anderson, the treating psychiatrist, received full disclosure of the board's decision. So I just want to ask you, is your statement based on knowledge from Dr. Liu that, Ms. Liu, that she gave him that information, both those psychiatrists, because the ALJ's statement is that that was not true. So I'm confused of the two. They're sort of opposing statements.
Yeah, let me clarify that. It's a good question that I need to clarify. The actual written decision from 2007 had not been provided to Dr. Brady except in the administrative hearing itself. He was confronted with that and said that he was aware of the facts and did not change his opinion. He had received the facts underlying the 2007 decision from Samantha, from Dr. Anderson, and from Professor Spire. He interviewed both of those to get their understanding of the facts related to it, but the actual written decision was not provided to him in advance of the hearing.
So am I correct in assuming that Ms. Liu did not provide either of them the actual copy of the board's decision?
That's correct. This is an oversight on my part. I probably should have provided that rather than giving him a summary of the facts and have him interview the people who knew Samantha and get the information from Samantha herself.
Okay, thank you.
Mm-hmm.
Yes.
So are we to assume that Mrs. Liu is not going to have any comments?
I'm sorry, I didn't hear that.
Does Mrs. Liu have any comments at all?
If she would like to speak, I will swear her in, and there's about...
Yes, she would like to speak.
There's about 45
Yes.
seconds left. Then why don't we take this time and let me swear you in at this time. So, Ms. Liu, if you'll please rise. Raise your right hand. Do you solemnly swear under penalty of perjury that the statements you will give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, please have a seat, or you are also welcome to stand, whichever makes you more comfortable. And you've got about 45 seconds.
Thank you. Well, first I'd like to comment on Mr. Mercer, what he said about I did this for my gratification. That is entirely not true. I didn't get any gratification from what I did. Instead, it was suffering. I did not intend to do any of this. Just want to make that clear. Now I'm going to start my speech.
Well, you have just a little bit of time, so I will give you a little latitude if the board wishes. Yes, you may proceed. Any objection, Mr. Mercer, to her speaking?
No, Your Honor.
All right, you may proceed.
Thank you for giving me this opportunity to be here. I regret that I made a series of mistakes over 11 years ago. This painful experience has been life-changing and vital for my growth. It gave me opportunities to learn, to understand more deeply about myself and my responsibilities as a physician. to appreciate more fully my wrongdoings and make sure they'll never happen again. This tragedy also forced me to confront my denial of a bipolar II disorder for many years. Reading the 2007 decision in retrospect, again and again, I can see that I was suffering from a manic or hypomanic episode of bipolar disorder. After that, I have finally received the proper treatment I needed. And my condition improved a lot. Now I look at the description from 2007, I couldn't recognize that I had done that. It's horrifying to me right now. Right now, I recognize that it's important to follow my psychiatrist's direction diligently in order to maintain my emotional stability. And because of that, my condition has been stable for at least over the last 5 years. Also, with the help from Dr. Anderson, I learned to deeply understand patients' feelings. Protecting patient safety is paramount. As Mr. Mercer has stated, I realized that my subjective memories contaminated with strong emotions during a time I was hypomanic affected my views of reality significantly. I have now been reviewing what happened before in a more objective point of view, and I can see how other people can see it very differently. In the Professional Boundaries and Ethics CME program, I have been able to formulate the psychodynamics that led to my boundary violations and develop an action plan to protect the patient and myself. Discussions among the peer group helped me feel supported while on the road of recovery. Maintenance and accountability seminars followed after the 3-day conference, helped me continuously learn from real-life cases from physicians all over the country. For the last at least 5 years, I have actively sought ongoing consultation and mentorship from Dr. Patricia Spire. She helped me understand my vulnerabilities and figure out the psychodynamics that led to my wrongdoings in 2004. We discussed transference and countertransference issues. She told me how my deeply ingrained traditional Chinese culture values had affected me in the way I perceived the 2004 incident, submitting to a demanding and intimidating male authoritarian figure because of fear may seem like coercion to me, but may not be in other people's views. I used to be weak and timid. Dr. Spire helped me to be stronger. I have worked extremely hard for 8 years to rehabilitate from mistake I made
Ms. Liu,
11
if you
years
can-
ago.
Ms. Liu, we've given you a number of extra minutes. If you can wrap it up a little, maybe in 30 seconds or a minute.
Okay,
It's been about 5 minutes.
okay. I
speaking.
believe I'm ready to return to serve the public without making similar mistakes. I want to make valuable contributions to community and society Like I do at Red Cross now and more. I'm passionate about helping the underserved Chinese American immigrants and youth who otherwise have very few alternatives. Please give me the chance to show you that I can practice safely. I have worked diligently in hope to be able to practice medicine again with full integrity and high ethical standard. I promise you will not be disappointed. Thank you.
All right, in light of our having given the, Ms. Liu about 5 to 6 minutes to speak, Mr. Mercer, is there anything further that you need to say at this time?
No, Your Honor, I believe that what we said earlier covers the topics raised by Ms. Liu.
All right. Then at this time, the board will be meeting in closed session. We thank the parties. Before the parties leave, first, we are off the record. Before the parties leave, I have the court reporter form to give each counsel and the court reporter. Ms. Yang, how many pages were there? 32. All right. And I have about 10:10. What time did we begin opening argument on this? About 9:20?
9:20, yes.
All right. 1 second. I will just fill these out, give them to the parties, and then we will meet in closed session.